Well, some years ago, I was invited to give a talk on advanced healthcare planning in a parish, and it had been organised by one of the local groups in the parish. And I went around long and spoke about advanced healthcare planning, but in particular I spoke about the particular model of an advanced healthcare directive that we have in Queensland. And I spoke about some of the problems that I saw with that particular model of an advanced healthcare directive. After the talk, and I was just meeting with some of the people and one of the organisers, he came up to me and said, that was really an eye-opener. I'm a financial planner and I've been giving those documents to my clients, advising them to do something about an advanced healthcare directive. And he said, do we have any other options? And so that started me thinking then about what were our other options. Now, when you think about it, and I came across some other financial planners and solicitors afterwards who told me the same kind of story, it's actually an ideal opportunity. People go to the financial planner often around about the time of retirement to plan their retirement and their financial affairs. And it's quite natural for a financial planner who's quite well informed to perhaps suggest to his clients, you might also like to consider this, your future health care. And similarly, if you go to a solicitor and you're preparing your will, then it would be quite natural for a solicitor who knew about these things to suggest that you might want to think about this. Now, the only option that most of them seemed to be aware of, though, was this Advanced Healthcare Directive. Now, the Queensland Advanced Healthcare Directive, if it is properly executed, is a legally binding document. And I believe it's a very blunt instrument, and it has a lot of problems, particularly for healthy people, to be filling in such a directive which says that they want such a treatment or don't want such a treatment without any real awareness of what their situation is going to be in the future. And so I think it's important that they too come to understand that there are other options than simply the Advanced Healthcare Directive, particularly in the Queensland model. I think the document on advanced healthcare planning and the model of an advanced healthcare plan that CHA has produced helps people in various ways. First of all, it talks about the kind of thinking we should have regarding our future health care, and that yes, it's appropriate that we might think that some treatment is the kind of treatment that we would consider too burdensome and would prefer not to have. But what the document helps us to do is to understand why we might say that we don't want some treatment and why we want some other treatment. The latest document also gives people a bit of a model of how they might express their wishes for their future health care, and also that combined they explain why we think that the better option is normally to appoint someone who will be your advocate, who will be your enduring power of attorney, who will be able to speak on your behalf when you are no longer competent, in accordance with your wishes. It's important to have that kind of flexibility in your planning, because none of us know what the scenarios are going to be like that unfold before us. By having someone who's able to speak on your behalf, they're able to address the real situation as it actually occurs, still with full knowledge of what your wishes are, but being able to take into account what the real situation is here and now. I think we need to promote to financial planners and solicitors through our various networks to make them aware of the options that are available, to make them aware of the resource that Catholic Health Australia has made available, that there are other options, other ways in which people can conscientiously plan for their future health care to take effect when they themselves are no longer competent. And so there's various ways, just promoting it obviously just through our own parishes, but through our other various networks to actually target explicitly perhaps our legal profession and the financial planning profession. I think one of the values is that this document helps to give people the language with which to be able to speak about their future health care in a way which is in keeping with our genuine respect for human life, but also respect for the wishes of the individual. And that is in particular the language regarding the assessment of the benefit and the burden of treatment, rather than talking about the quality or the value of a person's life. I've been helping people use that language for some years. By using that language, the family members or the patient themselves use a language that even the doctors and the medical profession can identify with. If you ask a doctor or a member of the medical profession, what's the benefit of this treatment to me? And what are the side effects going to be? What are the kind of burdens it's going to bring with it? They can usually answer that question fairly easily. They've got that experience, and that gives you the proper kind of information to allow you to make the assessment whether, oh, that sounds like it's going to be very, very burdensome for me given my situation at the moment. Or that sounds, yeah, that's going to be beneficial. I can see how that's going to help me. So it's giving people, it seems to me, that confidence, but also giving them the language in which they can discuss these issues in a way which takes us away from the idea that we're judging the value of this person's life. Our focus is on the value of the treatment or the course of treatment that's being proposed, given the situation of the patient, and making an assessment based upon that in accordance with, as much as possible, their own wishes as they've made them known. In our tradition, we obviously respect human life, and we have an obligation to take care of our life as much as reasonably possible. And so we have health care, etc., all the things we do to recover from illness. But all those kinds of positive obligations have limits. And when it comes to our health care, first of all, we are not obliged in any way to undergo what we call futile treatment. Futile treatment can be misunderstood. When I use the term, I mean treatment that doesn't achieve its specific purpose. So it's not that someone's life is futile, but it's continuing with the kind of treatment that, for example, is meant to be curative, but it's not going to cure. And so if that's its purpose and it's not going to succeed, then it's futile. Now, sometimes treatment that is normally curative might also be palliative. In other words, it relieves the symptoms. So you might continue that treatment for symptom relief, even though it's not going to cure. So you have to understand what role the treatment's playing. But the other one, and this is much more difficult, is I've used that term, treatment that is overly burdensome. Now, some doctors sort of say, oh, yeah, can you give us a list of burdensome treatments? Well, no, we can't. It's not that kind of thing, because there is a very subjective element to considering what is burdensome. So it's a question of that the individual thinks that treatment is really too much for me in my circumstances in this situation. Now, one example which occurs fairly frequently would be someone, for example, who's been on dialysis for a long period of time. They can sometimes get to the stage where the dialysis is just too much for them. And they say, I can't do that anymore. Now, that's not being suicidal. That's saying the treatment is now overly burdensome. It's too much for me. And they say, I'm not going to go through it, knowing that it will shorten their life. They will die shortly thereafter. But that's recognising a treatment that's too burdensome. For some people, it might be going through some forms of therapy for cancer. They might decide that the benefits they're going to get from it are so short term and are going to produce side effects that they don't want, and they prefer to stay the way they are than to go through that. And it's not something anyone can give categorical answers to. It depends on the situation and the patient themselves making that judgment whether this treatment is going to cause too much discomfort, too much stress, too much pain. It might be the difference between dying at home and dying in hospital. Someone will find it too burdensome to be moved from home into hospital. Even though going to hospital might prolong their life for a short period of time, they prefer to stay at home where they don't get the same kind of technological treatment, but are allowed to die in peace. There's a whole range of examples we could go through, but that might give you some of the ideas of what's involved. The documentation on advanced health care planning from Catholic Health Australia is aimed primarily at the situation where the patient, is no longer competent to express their wishes. Whatever we're competent, there's no problem, because I can talk for myself. I can say what I want and don't want. But it's good if I've thought about it in advance. What about when I can't speak for myself? And so I need to communicate about that to someone else and to appoint someone who will speak on my behalf, so that what I might consider to be overly burdensome in these circumstances is taken into consideration, and usually someone who's close to me. And in the past, we've simply relied upon the next of kin, and that's been a reasonable approach to take. But today, with the way legislation is, sometimes we need to put things in a formal fashion to appoint someone to actually be that spokesperson for us. If we appoint someone as our spokesperson, that will normally be a legal document. So in Queensland, it would be enduring power of attorney for health matters. And that means that they are the person who's legally entitled, when you are no longer competent, they're legally entitled to speak on your behalf. Now, if you don't appoint someone, the legislation in Queensland has a hierarchy of people that it appoints. So they become your legislative power of attorney, as it were. So if you're married and in a continuing relationship, your spouse is automatically your power of attorney for health matters when you're no longer competent. After that, it becomes a carer, and that's properly defined in the legislation. And then after that, it becomes other next of kin or friends. Some people wonder about that hierarchy, and it's just important that people understand that there is a hierarchy established by law in Queensland regarding who is your spokesperson if you are no longer competent. And if you're not happy with that hierarchy, then you definitely need to appoint someone. So the document that we have on Cathy Health Australia isn't the document for appointing the attorney. It's nominating who we want to be our spokesperson, but for that to have legal effect, at least as far as Queensland went, it would need to be through an enduring power of attorney for health matters. A lot of financial planners and solicitors are already initiating a conversation on this matter. I think in actual fact, when someone goes to talk about, say, their superannuation and their retirement and their plans for their finances with a financial planner, or they go to a solicitor, and particularly when they're drawing up their wills, both of those seem to me to be opportunities for financial planners and or solicitors to raise the question, have you considered anyone to take care of your financial matters if you are no longer competent? And what about your health care if you are no longer competent? And do you know that there are certain options available in that area for you to do? And similarly with a solicitor who's dealing with a will, you're appointing an executor. Have you considered what might happen if you're still alive but no longer competent to make directions regarding your finances or your health care? Now, they're two different issues. The financial power of attorney is different from an enduring power of attorney for health matters, but it would seem to be an easy way for both solicitors and financial planners to lead into that question.